Welcome to this training for eviction defense in Virginia and the Eviction Legal Helpline. I am Phil Story. I'm the Eviction Legal Helpline Director.
And I'm Christy Mara. I am the Director of Housing Advocacy here at the Virginia Poverty Law Center. Together, Phil and I are going to give you a little bit of background as to why this work that you are volunteering to do is so important. And then we're going to dive into the laws that you need to know in order to be able to do this work. And finally, Phil,
we will be giving you an introduction to the Eviction Legal Helpline as a project that needs the help of smart lawyers like you, who, with a little bit of training and excellent support and supervision from us, can make a real difference in the lives of our neighbors who are facing potential eviction. So we are with the Virginia Poverty Law Center, and we, through advocacy, education, and litigation, are trying to break down the systemic barriers keeping low-income Virginians in cycles of poverty. The outline for the training is we're going to start with a brief description of Virginia's eviction crisis, and then the legal context of eviction, followed by the bulk of the training, which will be on common legal defenses to eviction. And that's going to be organized by procedural posture of a case. That's the way the support materials for the Eviction Legal Helpline are organized, so that it's easy for our volunteers to, when a case comes in, to look at, okay, what is the procedural posture of this case, and then look up what are the defenses that are most generally applicable at this stage. So we'll go through that, and then the introduction to the Eviction Legal Helpline, followed by a Q&A session.
So about 3 years ago, the entire country learned something that we, as longtime legal aid lawyers, had known for decades, and that is that Virginia was eviction central for the country. Matthew Desmond had just released the first data set from his eviction lab work, and it revealed that 4 of the 10 large cities in the United States with the highest eviction rates were right here in Virginia.
5 of the top 10, in fact.
Oh, how I block things out when they're painful, Phil.
Yeah.
I really do. You are absolutely right. Chesapeake, Norfolk, Newport News, Hampton, and our very own Richmond rank in the top 10 of naughty states, as you might say, for having appallingly high rates of evictions of residential tenants. And one thing that's been talked about a lot, but one thing that's been really sort of overlooked is the fact that we also had 3 mid-sized cities rank in the top 5 of the highest evictors in their category. And that was Petersburg, Hopewell, and Portsmouth.
So those are the kind of the big numbers. It made a splash, of course, on the cover of the Sunday New York Times in 2018, and really focused attention of policymakers on that issue, thankfully. But what does this crisis, there is a crisis, what does the crisis look like? And this is something that we have seen as legal aid lawyers, longtime legal aid lawyers, and we're seeing it through the work of the Eviction Legal Helpline. But what it looks like is a mom of 2 teenagers, lives in Southwest Virginia, whose landlord decides he doesn't like having them there anymore just a couple of months after they signed a lease. And so the landlord starts harassing them, threatening to call the police because the children are unsupervised, these kids in their late teens, calling the mom. The mom has to deal with this during work hours, eventually loses her job because she has to deal with this harassment and these threats from the landlord, who then files an eviction case against her. It looks like an older gentleman in one of the small cities in this state who relies on a nebulizer, and when he falls behind on rent, the landlord cuts the electricity. It looks like somebody who is making their living, driving their truck. Well, then the pandemic happens, and there's not a lot of commerce, not a lot of work for a truck driver, and so the landlord threatens to, and actually does, cut off the water to the mobile home that the the family lives and threatens to actually light her truck on fire. And it looks like a family living in a mobile home park in central Virginia. The landlord decided they had to get out. She caught up on rent, had everything paid up, which by law means that she can leave the home in the park for 90 days after the eviction case against her. But the landlord decided he wasn't gonna abide by that and actually yanked her home off the lot. In doing so, of course, this older mobile home lost much of its value, and it got parked out in a vacant field. And it looks like hundreds of thousands of other cases just like this every year in Virginia. So the numbers for 2019 were over 200,000 eviction cases filed in General District Court in Virginia. So these are the kinds of things that are multiplied over and over and that affect our neighbors.
And as terrible as those stories that Phil just relayed are, sometimes the aftermath of eviction judgments are even worse, because once you have that scarlet E on your record, you are destined for at least a few years, if not longer, of struggling to find decent, safe housing that's affordable for you and your children. Landlords routinely ask for various records when they're screening tenant applicants, including and especially any record of court involvement for eviction. So once an eviction is filed against a family, even if it's ultimately dismissed by the court, it is something that a landlord will use against that family to deny them housing.
What does that mean for lawyers and for the kind of work that we do and the kind of work that volunteers on the Eviction Legal Helpline can do? Well, there is a legal context to eviction. So what are the laws that govern evictions from residential properties in Virginia? There are the big ones. The big one is the Virginia Residential Landlord and Tenant Act. And that covers most residential occupancies. So it is our assumption that unless it's a manufactured home in a park, or perhaps in some cases a short-term stay in a boarding house or in a nursing home or something like that, that the tenancy is covered by the Virginia Residential Landlord and Tenant Act. And so our support materials and the things that we're going to be explaining in this presentation are mostly drawn from the VRLTA. There's also something called the Manufactured Home Lot Rental Act. That is for lots in mobile home communities that the community has at least 5 units. So this governs if somebody owns their home or if they're renting their home, but they are also renting the lot that the home sits on. This governs their rights and the procedures that landlords have to follow. Then there are federal regulations for subsidized housing. That affects a lot of people. So folks who are living in public housing, who have housing choice vouchers, who have site-based Section 8 subsidized housing, who are in developments that were built with low-income housing tax credits. Those folks have extra protections that aren't part of the VRLTA, but are important for their legal context as they're facing potential eviction. And then there are just procedural requirements for filing and carrying out unlawful detainers, which are the lawsuits to evict folks.
In addition to the Virginia Residential Landlord Tenant Act eviction defenses that we'll be talking about later in this presentation, there are a number of things you should know about protections that are particular to the era we are in now, the COVID-19 pandemic era. There are particular requirements for termination notices that apply through June 30th of 2022.
Federal CARES Act was passed in the early days of the pandemic in March 2020, and it initially provided for fairly robust protections for people against being evicted for non-payment of rent during the summer of 2020. certain properties were covered by that. Properties that had any kind of involvement with either federally backed loans or with any subsidized housing programs or anything like that. So the eviction moratorium protections that were in place for the summer of 2020 expired, but the notice requirements remain, and there's no sunset on those. So it's very specific, it's very narrow, but if a property is covered by the CARES Act, then if they want to evict someone for unpaid rent, they have to give that person a 30-day notice before terminating the lease. So you'll see in a minute that the state notice requirements are 14 days. But if they're covered by the CARES Act, they have to also give a 30-day notice before they can terminate.
The other things that we're going to talk about on this slide are state provisions that do sunset. First and foremost, prior to the pandemic, landlords were required to give tenants a 5-day notice that they had to pay their rent, or the landlord would proceed with eviction. The eviction process would begin that. Since shortly after the pandemic started, and continuing through July 1st, 2022, landlords must provide a 14-day notice to tenants if their rent is not paid on time. And this 14-day notice must advise the tenants that they have until the 14th day to do one of the following: pay all the rent that is due, including the late fee. They can either pay all of that by the 14th day, or the notice also gives them the opportunity, the right, if the landlord owns more than 4 rental units, to enter into a payment plan to pay off the rent for that month. And finally, and probably most importantly, and this is what we are referring to as Virginia budget amendment provisions, that 14-day notice must inform the tenant of the availability of rental assistance money to pay their rent through the Virginia Rent Relief Program and any other programs that are available, and must give them information on how to reach 211, which will tell them about other available programs. The budget provisions require that this notice be given with all of the information about the rental assistance, and they prohibit a landlord from initiating any steps to take possession of the unit until they have given that notice and applied for rental assistance on behalf of the tenant, unless the tenant has told them that they've applied on their own, has paid the rent in full, or has entered into a payment plan with the landlord.
The steps of the legal eviction process, they start with a notice of lease termination. Then the landlord files an unlawful detainer with the general district court. Then there's a return date, the first court date, where both parties show up. Then there could be a trial. If there really are no issues in dispute, a lot of times it'll be dealt with just at the return date. If there are issues in dispute, they might schedule a separate trial. So after the trial, then there's an appeal deadline. That appeal deadline is 10 days for unlawful detainers. And then the landlord can ask the court for a writ of eviction. The writ of eviction is issued. The sheriff serves that. And then at least 72 hours after serving that, the sheriff can go back and actually execute the writ of eviction. That's when it ends. The person is physically removed from the property. Locks are changed. Sometimes property is put out on the curb, but that's the last step in the legal process of eviction. Talking about the common legal defenses to eviction. So this is the heart of the CLE. It is covered in the eviction defenses outline that we have with the training materials. And so we're going to talk through these, and they're going to go in order of procedural posture. So this is the reason why they're in this order is because when you are volunteering with the Eviction Legal Helpline, then it's easy to, based on what point the caller is in the legal process, you can kind of orient yourself to what are the issues that are most likely to be effective at this point in the process. So before that, we start way before the process. So one of the first things that we want to find out from a tenant and from the court records is if they have an old judgment for possession from their current landlord within the last 180 days. So what the law says is that once a landlord gets a judgment for possession, and let's just say it's not only about money. Let's say it's about some other lease violation. That is going to make it a little more simple. But then once they've got that judgment for possession, assuming they gave the client proper notice, which most professional landlords do, but some do not, then for the next 180 days after getting that judgment, they can, without going through any other court process, go down to the court and get the court to issue a writ of eviction, which of course is instructions to the sheriff to carry out the eviction within the next 30 days of when the writ is issued. So a landlord can do that even if they sort of, kissed and made up with the tenant, and the tenant thinks everything is fine and they have remedied whatever dispute they had. But the landlord decides, you know what, my brother-in-law needs a place to stay, and so I'm just going to kick this tenant out because I have this old judgment for possession that is less than 180 days old. That's what they can do. So what we want to find out is, does this tenant have an existing judgment for possession with the same landlord within the last 180 days? Because that can affect really the practical outcome of maybe finding new defenses for a new dispute that the tenant has with the landlord. So if the landlord has entered into a new lease since the judgment with the tenant, then they can't get that writ issued on the old judgment. If the landlord received payments since the judgment and never gave a tenant the notice of receipt with reservation, never being the key word there, because a landlord doesn't have to give it each time they receive a rent payment, but at some point.
Well,
and often with that notice of receipt with reservation is included in the termination notice or the 2130 notice or the 14-day notice or whatever.
one thing to be sure you're looking at is whether or not that notice of receipt with reservation had the required statutory language. As of July 1st, 2021, there are specific words that landlords must use in that notice.
Yeah, and that is literally in the code. It is in quotation marks. So this is language that has to be included. Some landlords are more careful than others, and so that can be something to look at. So the other thing is, if the judgment was based only on unpaid rent and the tenant has paid up everything they owe, and everything they owe is going to be, any kind of the judgment that they were awarded, subsequently accrued rent, court costs for that the court awarded, attorney's fees that the court awarded, all of that stuff. If the tenant has paid to a zero balance, then and the judgment was only based on unpaid rent, then the tenant redeemed, and so the landlord cannot then go get a writ based on that older judgment.
One of the most important things for you to know, and one of the things that I have found in my career as a legal aid attorney tenants don't know, is that a landlord cannot put a tenant out lawfully without first going to court. We know that landlords are still trying to circumvent that process. We saw actually a rather alarming spike in unlawful evictions during the early part of the pandemic. So what is an unlawful eviction? Well, quite frankly, any action taken by the landlord to force a tenant out of their home without getting a court order first. We see people who change the locks on the doors to the dwelling unit. We've heard of people taking the door off the dwelling unit to make it unsafe. We've heard of landlords who took all of the windows out of a mobile home to make living there unsafe, to make it uninhabitable. It's not uncommon for landlords who want to circumvent the legal process to cut off essential utilities like electricity or water or gas. And then finally, we hear a lot of tenants tell us that the landlord said they had to be out by X day or they were going to come and put their things on the street. All of that is unlawful. There is and has been for a while an action that the tenant can file in general district court through a Supreme Court forum called a Petition for Relief from Unlawful Exclusion. Unfortunately, that was not deterring landlords from taking these unlawful actions if they were inclined to do so, because what would happen is the judge would look at the court records, find that there was no valid judgment of possession, and simply give the tenant or serve on the landlord an order that says, let the tenant in and go do it the right way. Well, that doesn't harm the landlord at all. So if you're an unscrupulous landlord, why not try to save the 60, 70, 80 bucks that it costs you to file an unlawful detainer action in court? Now, as of July 1st of this year, landlords who are found to have unlawfully evicted a tenant in violation of the statute can be held liable to the tenant for $5,000 in statutory damages, in addition to the actual damages that were always permitted under the statute. Actual damages generally don't amount to much because it's hard to quantify what it costs to live with a relative for a few nights or stay in your car for a few nights, which is what a lot of tenants experiencing unlawful evictions will have to do. So the statutory damages provision, we hope, will be a real game changer. And hopefully by now word has gotten out that if you take law into your own hands as a landlord and evict somebody without going to court, you can be liable to that person for $5,000 or 4 months rent if that is more than $5,000.
Yeah, and that's a shall, so that's not a discretionary penalty statute. That is a shall. Okay, so a landlord can't just evict somebody without following the legal process. Legally, they can't do that. So the legal process starts with basically a notice of termination or a notice to vacate. So these can be, depending on what they're based on, there's a variety of notices. They have different time frames and different requirements. But so there's a termination by right or an expired lease. So for example, you're on a 1-year lease. Oftentimes the lease will say that at the end of the year, if either party gives the other at least 30 days notice that they're not going to continue there, then the lease will end at 1 year. If nobody gives that notice, then it'll roll over into a month-to-month lease. So the landlord at 10.5 months or whatever can give the tenant termination notice and say, we're not going to renew the lease. And so that's something that we'll see pretty frequently. A lot of people are on month-to-month leases, especially with the pandemic and the eviction protections that were in place. A lot of landlords were letting folks go onto a month-to-month lease, and then rather than trying to go through the jump through the hoops to evict somebody based on unpaid rent, they will just say, hey, we're non-renewing your lease. And so you've got to be out in 30 days or at the end of next month or whatever. So that's something that that will start this process. And we always want to check to see, is this notice adequate according to either the rules that are in the statute, if the lease doesn't specifically address the amount of time has to be given, or the requirements of the lease for when a notice has to be given to non-renew. So a pay or quit notice, also sometimes called a notice of default or a notice to vacate, it's a notice for unpaid rent. And so it gives somebody the right to remedy that. Now, traditionally, it's been a 5-day period. Now, because of the pandemic, there were some laws that were put in place to extend that to 14 days. They're currently going to sunset, scheduled to sunset at the end of June of next year. but we're hoping that we can make those permanent. So the pay or quit notice will say, you're behind on rent. Here's how much money you owe in rent. If you pay that within the next 14 days, then everything goes back to normal. If you don't, then after those 14 days, we can terminate your lease and file an unlawful detainer against you. Now,
But wait, there's more.
There is more. So because of the good laws that folks like Christie and others got the General Assembly and the governor's office to put in place, there are additional requirements for people, for the notices for people who are facing potential eviction for unpaid rent. So they have to give the person information about a payment plan option. Now that's for landlords that have more than 4 rental units. They have to offer a payment plan. They have to allow the tenant to enter into a payment plan once in a lease term. And so if somebody, say, enters into a payment plan in January, but they can't keep it up, and then in July, they fall behind again, they eventually catch up. In July, they fall behind again. The next 14-day notice does not have to offer a payment plan because they got that option, they used that option, and they don't necessarily get that again. But until the person uses that option, every 14-day notice does have to offer that. And
if you're a larger landlord.
And then all landlords are required in that 14-day notice to include information about the Virginia Rent Relief Program. The information there, and in our support materials, we explain it very clearly, but that information has to include notifying the tenant that they might be eligible for this and how to apply, and to contact 211 Virginia to see if there are any other funds that might be available. It also has to tell the tenant that unless within the next 14 days after receiving this notice, the tenant either pays their full balance or enters into a payment plan or tells the landlord that they have already filed or begun an application for the rent relief program, then the landlord will file their own application on behalf of the tenant for rent relief. That is required. Those are all things you definitely are going to want to look at somebody's pay or quit notice and see if it includes all of those requirements. If it does not, then under the budget amendment, they should not be able to take any action to evict that person, including filing an unlawful detainer against them. Then there's a 2130 notice, which is a notice for a remediable breach of the lease. So, for example, the lease clearly states no pets are allowed, and somebody has gotten a dog and they've got this dog in their apartment. The landlord is supposed to give somebody a 2130 notice. That's something that can be remedied. Somebody can find another home for the dog. And so you give that notice gives the tenant 21 days to come into compliance. It states that if the tenant does not come into a compliance within those 21 days, then after 30 days from the date of the notice, the lease will terminate and the landlord can file an unlawful detainer against the person. So you want to look at the 2130 notice. As Christy said, make sure that the dates that the landlord is calculating are correct. A 30-day notice for non-remediable breach. So there's actually kind of two things in that. If it's a repeat violation of the exact same kind as somebody earlier got a 2130 notice for, so they moved the dog in with a family member, but then a couple months later the dog is back, then the landlord doesn't have to give them an opportunity to remedy that. They can give them a 30-day notice. But if it's a non-remediable breach, also the landlord gives the person a 30-day notice. Non-remediable breach would be things like physically assaulting one of the staff members or a neighbor or something like that. Things that you just can't put the genie back in the bottle on, right? Those are non-remediable breaches. And so the landlord can give them a 30-day notice. And those, of course, whether a breach is remediable or non-remediable is going to be an issue of fact and law that can be argued in court. And so you're going to want to look at that 30-day notice and say, is this breach really not remediable? Or was this even a breach at all? And see if the notice and the alleged breach are valid with that. Now, if there's a non-remediable breach that is a criminal or willful breach, that affects the health and safety or is about illegal drugs, then the landlord will almost always give a written notice, but doesn't have to be a 30-day notice. So they will frequently give like a 72-hour notice or something like that. But if the tenant's mobile home that they're renting blew up because of the meth lab that they were running in there, the landlord doesn't have to wait 30 days to evict the person.
Landlord probably isn't going to be the one evicting the person.
Yeah, probably. Yeah. So if a unit becomes uninhabitable due to fire, flooding, or other accidents, that's another type of termination notice. It's a 14-day notice. And again, that is disputable if the facts are such that it looks like the landlord is just trying to get out of this, but really it's not uninhabitable, or it is not the type of a situation that cannot reasonably be repaired while the person still lives there. If a property is foreclosed on and the former owner is living there, then the new owner can give them a 3-day notice that says, you've got to get out. If you don't within these 3 days, I'm going to file an unlawful detainer. If a landlord is going to rehab or convert a property, you're in the middle of a year-long lease, but they want to convert your unit from an apartment into a condo and get in there and do some work, they have to give you 180 days written notice. And then there are other requirements for termination of a subsidy from a housing authority. So those are all some more common and others less common notices, but all notices must be in writing. They must be served on the tenant, and they must specify acts or omissions constituting the breach. So we had a case just recently where the tenant sent us the 14-day notice, and it was handwritten on a little memo pad, and it said, you're in violation of the lease, you have to leave in 14 days, period. Well, that doesn't specify any acts or omissions, and so that's a defective notice. Should, if they file an unlawful detainer, they should be able to get that dismissed because the notice is defective.
So a defective notice is a defense that a tenant can raise at that initial court date, which we call the return date. And right now, and until the end of June of next year, there are lots of ways the landlord can mess up the notice, and Phil went over pretty much all of them. But I think what is happening probably most frequently right now is that they are making a mistake in terms of this special additional language that the budget requires them to include. So if you're talking to tenants who have received that notice, check it against the screen talking about what needs to be, or the page of your manual, what needs to be in the notice right now pursuant to that budget language. It's got to have the number for 211. It's got to talk about the Virginia Rent Relief Program. It has to tell the tenant that if they don't apply for the Virginia Rent Relief, then the landlord will apply no later than 14 days after sending the notice. If any of those things are missing, or there are any of the numerous other defects that may come up, that is something that the tenant can and should be able to do on their own, raise at the return date, at that first court date. As I said earlier, could have been this year, could have been last year, but at some point in the not too distant future, thank you, the General Assembly added a requirement that a landlord provide to a tenant at the signing of the lease a statement of the tenant's rights and responsibilities that can be found on, it's a form on the Department of Housing and Community Development website. If that is not provided to the tenant, the landlord's case has to be dismissed, because it's very clear that a landlord cannot maintain any court action against a tenant until he provides the tenant with a copy of the rights and responsibilities. We talked about the importance of counting. Counting is important. So you want to make sure that the tenant was given sufficient time to make that payment. Did the landlord file the unlawful detainer on the 13th day? Did the notice say you've got until the 15th when really they had until the 16th? That makes a difference and makes the notice defective, even if they waited until the 17th to file. And then we used to call this the fictitious name defense. Basically, you see a lot of landlords, a lot of small landlords in particular, who feel compelled to rent their properties in the name of some LLC they make up. And what happens is they screw it up. If the landlord has not filed something with the SEC or with the court that shows that, you know, Christy Mara is Ritzy Limoncello LLC, and then I bring an action under Ritzy Limoncello LLC, guess what? Ritzy Limoncello LLC is not an entity, is not a person, doesn't count. It's not the person who can bring the action. So that's important. And then Phil has already talked about the importance of the right of redemption. Oh, and that is something you would raise at the first court date. A tenant does have an extended period of time to redeem now, but if a tenant has paid everything that she owes the landlord on or before the first court date, which at that point would be the rent, the late fees if they're contracted for in the lease, attorney's fees if contracted for in the lease, and court costs, and any additional rent that may have accrued between the time of the filing and the time of the return date, they can pay that on or before that date, and the case must be dismissed. That is redemption.
For cases that are only about unpaid rent.
For cases that are only about unpaid rent, there is this weird quirky thing that I don't know if anybody uses anymore called a redemption tender. If you get a letter from a nonprofit or a local government agreeing to pay the amount owed, and you bring it with you to that first court date, then you have the right to get the case continued for 10 days so that the payment can be made. In these days of federal emergency relief assistance and the Virginia Rent Relief Program, this is somewhat irrelevant, particularly with the requirements of the landlord applying to get the money themselves. Some additional defenses that a tenant can raise at the return date is simply that, hey, judge lady, I paid it all. Here's my receipt.
If all the rent was paid before the case was filed, the tenant shouldn't have to pay court costs or attorney's fees.
Now, one thing you will see is that the landlords will claim attorney's fees just for sending out the pay or quit notice, which is ludicrous.
Well, some leases actually put that into special provisions, and the tenant agrees to pay that. Many leases do not, and yet landlords try to do that.
We do have instances where landlords want the tenants out, and so they won't take their money. Now, this is actually happening more frequently now, in that even when a tenant applies for the rent relief, even if the tenant somehow manages to get the money without landlord's cooperation, which would be odd, but could happen if it's from a different kind of rental assistance program, we have landlords saying they don't want that money. That becomes a defense for the tenant. And again, a tenant who has offered payment, landlord refuses, should hold on to that money, because when he gets to court, he's now got two defenses. Number on the first return date. Number one, landlord won't take my money, and number two, hey, judge lady, I can redeem right now. I got the money. Now, it is possible in some cases for the tenant to withhold rent lawfully, but they're very, very limited. They both relate to the landlord not making repairs that are needed to keep the dwelling unit safe and habitable. One situation is where the tenant has filed a tenant's assertion with the court. In that case, the court is going to require the tenant to pay rent into escrow in the court. And so there will be a clear record that that payment has been made, it just hasn't been made to the landlord. I think the other one might be a little bit trickier, because for the past year and a few months, because this went into effect in 2020, the tenant has been allowed to make more minor repairs on their own if the landlord fails to do so after within 14 days of receiving notice.
And the way this works is that if there is a conditions issue that the tenant needs to be repaired, the tenant gives written notice to the landlord and says, I need this fixed. If the landlord, after 14 days after receiving the notice, hasn't made a substantial effort to repair the issue, then the tenant can hire a contractor licensed by the Board of Contractors to come in and make that repair and then the amount of the invoices that that contractor charges to make that repair, the tenant can then give to the tenant can give the invoices to the landlord, ask for a reimbursement. If the landlord does not reimburse them, then they can withhold that from their rent, up to $1,500 or 1 month's worth of rent. So that's something that a tenant can do, and then a landlord, in response to that, if they object, can ask for that rent money and potentially file an unlawful detainer against them. That's how they end up in court. So those are defenses that are most often going to be raised at the return date. What about defenses at trial? So now some of these can be raised at the return date, but the judge isn't going to want to get into too many facts at the return date. If there are enough facts in dispute or legal issues in dispute, the judge will set it for trial. So defenses that are most likely to come up at trial, one is the parties entered into a new lease after the previous breach. So after that 14-day notice, rental office was on autopilot and they renewed the annual lease of the tenant. Well, they acknowledged the tenant's right to be there, and so that's a defense to an unlawful detainer. So the breach was mischaracterized by the landlord. So the landlord maybe said, this is a non-remediable breach for whatever reason, and no, it was actually very remediable, or it wasn't even a breach at all. That is an obvious defense. The unlawful detainer might be based on the landlord's material non-compliance with codes affecting health and safety. So the landlord is suing to evict somebody because they say the person is causing mold or other kinds of problems. Well, no, the person actually had been requesting repairs to that, and it's the landlord's fault that these things are happening. The tenant is a victim of family abuse and cannot be evicted solely due to the abuse. Now, sadly, this is a very limited protection. If somebody does meet those narrow specific requirements, then that can be a defense in those cases. And if an unlawful detainer is filed as unlawful retaliation for the exercise of a tenant's protected rights. So tenants have certain rights, not a whole lot, but they have certain rights that are protected from retaliation under the Virginia Residential Landlord Tenant Act, under the Manufactured Home Lot Rental Act, fair housing laws, things like that. And so that can be a defense. If an eviction is discriminatory based on a protected class. Now, Virginia's fair housing law is more expansive than the federal has protected source of funds. So source of funds is very important, especially right now when there are funds available from the state, the Virginia's rent relief program, that many renters are eligible to receive to pay the rent that they owe and associated costs. So a rent relief program application can be approved to pay for the rent, for the late fees associated with that rent, for court costs and attorney's fees.
Anything necessary to keep the tenant housed.
Yeah. So as long as it's part of the lease. So if it's utilities that are paid separately and not as part of the lease, then that's another matter. But what we're finding is that a lot of landlords just don't want to be bothered with filing the minimal paperwork that they have to get these funds. So they could file to evict somebody because they just don't want to have to deal with this rent relief program anymore. Well, that is arguably a violation of Virginia's fair housing law because it discriminates based on source of funds.
Now, the simplest thing to do in those cases is to rely upon the law that's in effect through June 30th, 2022, and just argue that the case needs to be dismissed because the landlord did not meet the prerequisites.
From the budget amendments, right?
But what's even more fun, I think, and might be worth trying, although I don't think the tenant could do this on his or her own, there's a Fair Housing Act violation counterclaim. And the reason it's important to potentially, send some of these really clear violations to legal aid to get them to file counterclaims in addition to motions to dismiss the landlord's action is because one thing that we see often is a general district court judge who, instead of dismissing the UD, over which he does not have subject matter jurisdiction because the landlord didn't send the proper notice. They simply continue it and say, well, I'm going to let you guys apply for rent relief. No need to dismiss it. Well, if there's a counterclaim there, then you're like, fine, but it's also a lot more likely that the landlord's going to make everything go away. So it really gives everybody more, it gives whether a tenant is represented or not more leverage, but again, most of the time to raise that counterclaim, the tenant's going to need a legal aid attorney.
Or the other thing, so as this issue comes up, which it is likely to come up, to continue coming up, say on a shift as a volunteer attorney on the Eviction Legal Helpline, we definitely want to flag those cases. And then we at BPLC can decide to follow up with a referral to a legal aid, suggestion that a tenant call the Virginia Fair Housing Office, or if it looks like it's the tip of a much larger iceberg with, say, a large landlord or something like that, we can even check with folks at the Attorney General's office and see if they're interested in following up on a pattern and practice violation. So that is something that's going to keep coming up. There are still plenty of funds in the rent relief program, and so that issue is not going to go away anytime in the near future. So another defense at trial is that the landlord accepted rent after the alleged violation, but never gave the proper notice of reservation.
And this one's going to be a big one for the next few months while people are getting used to the new notice requirements.
Yeah. So with the budget amendment, if somebody has remedied their non-payment of rent, then a landlord cannot
that's
evict
correct.
them based on unpaid rent. Period.
That's correct.
Whether they gave notice of receipt with reservation or
But
not.
also, if somebody has made a partial payment between, when the case is filed and when they go to trial, the landlord must accept that rent with the statement that says a partial payment will not stop your landlord from evicting you. However, full payment of da, da, da. So there's some specific language in the code that I believe needs to be given by the landlord, even for a partial payment made after it's due but before trial.
So that is definitely something to look at and ask the tenant, since you got this notice, since this whole thing started, have you paid any rent? And if they did, what kind of notice did they get from the landlord? Then of course, if the breach didn't occur or if the tenant is not responsible. So sometimes landlords will decide that if somebody is an acquaintance of somebody else, then they might as well evict them because this acquaintance was not on the property with the permission of the tenant, but caused some kind of disturbance and they're looking for somebody to evict. So that's obviously something else that the defense can be raised at trial. If the landlord is attempting to enforce an illegal lease provision or an ambiguous term that should be construed against them, or an unconscionable lease provision, those are all things to look at depending on what the landlord is saying the violation is. If it's a mobile home park tenancy, an eviction from a mobile home park can happen for one of 5 reasons and 5 reasons only.
But this is only where the tenant owns the mobile home, right? Because otherwise it's covered by the VRLTA.
Yes. So if a mobile home park owner is trying to terminate and evict somebody from the lot, then there are only 5 permissible reasons for that. And so you can check and see that is covered clearly in our reference materials. Or if the breach is minor or remediable and has been cured.
There are some additional defenses that tenants living in subsidized housing have, and it's important to be able to spot these defenses or potential defenses. And we would much rather you err on the side of seeing a subsidized housing defense that isn't there than on the side of missing a subsidized housing defense that is there. So when in doubt, say, you might have a defense, Ms. Subsidized Tenant. Let us send you to a legal aid lawyer. So what are some of these defenses? Well, the landlord, it says miscalculated the tenant's rent portion. Now, if you're dealing with a public housing authority who is doing the calculation, or some other people who are actually doing the calculation of the rent, and you're not in a voucher situation, then yes, the landlord's miscalculation of the rent could be innocent, but it's still not, they could say you owe $800 a month and really it's $700 a month, and the tenant either paid the full amount, or if you're not on notice of the right amount, that in and of itself is defense. And that could be, obviously purely innocent. But I'm looking down at the second to last, and we hear all the time about landlords who are renting to tenants with housing choice vouchers, and they are in a contract with that voucher administrator, might be the Public Housing Authority, might be Virginia Housing, but that contract, which is called a housing assistance payment contract, will expressly say tenant's going to pay $300 a month, we're going to pay the balance of $900 a month, and you are forbidden, Mr. Landlord, from taking any additional payment for rent. But they do anyway. They say to the tenant, tell you what, I have a lot of people who want this unit, but I like you. If you could, I want to give you a leg up. How about you pay me an extra $100 a month? That is not permissible. And if the landlord is seeking rent that includes that extra $100 a month, he is coming forward with unclean hands. And I think the whole case should be kicked out. Don't know if that's how judges see it, but that's what I would argue. The subsidized tenant didn't commit a terminable breach, a material breach, a good cause breach. Again, if the tenant is living in subsidized housing, not a voucher living in private housing, but living in the subsidized housing, the landlord cannot evict that tenant for anything that doesn't qualify as good cause. Well, for the most part, good cause is the same as material, just so you know. The landlord, this is important. If you've got a landlord, again, renting to a housing choice voucher tenant, and we hear horror stories sometimes about some of the housing authorities not making the payments under the HAP contract until 2 or 3 months into the contract, that's not a reason to kick out the tenant if the tenant has paid his or her portion. That is an issue that the landlord must take up with the voucher administrator. And then finally, this termination for failure to report, that's termination for failure to report an increase in the tenant's income, which in turn would result in higher rent.
Or, your 18-year-old child moved out.
Right.
Like that.
Right.
So yeah, and that is only if it is knowingly done by the tenant. It's not if that was an oversight or something like that.
Intent is important.
Yeah. So those are now, again, as Christy said, for the subsidized housing, almost 100% of those cases that we get on the helpline, we are going to refer out to the local legal aid, because the stakes are so high for those residents that they need somebody on the ground who knows the housing authority, knows the judges, and deals with these issues all the time. And those are the frontline legal aid lawyers. So, as you can imagine, if somebody loses their subsidized housing, they get evicted from subsidized housing, they can have to wait like 5 years before they can be eligible for subsidized housing again. And of course, there's a long wait list that is much longer than 5 years.
They may never get subsidized housing again. And you can see how something like that could be the trigger that starts someone on a downward spiral.
Very easily could cost them tens of thousands of dollars.
Not to mention custody of their children.
Yeah. So we definitely want to refer those, but we wanted to include those defenses just for completeness here. So now, options after there's been a judgment for possession. So there's an appeal right that is within 10 days on unlawful detainers, and the tenant must file the paperwork and perfect the appeal within those 10 days, which must include a bond for court accrued damages. So let's say it's the case was about unpaid rent, it was for $5,000. If the tenant the landlord gets a judgment for possession and an award of those $5,000, the tenant within 10 days has to come up with more than $5,000.
So for our legal aid eligible tenants, their right to appeal an eviction case is a lot like their kid's right to get money from the tooth fairy.
Yeah. So, I mean, the good thing for them is that within those 10 days, no additional, the landlord can't actually execute an eviction. But it's, it is the right to appeal is very limited when there are damages involved. They can file a motion for a new trial within 30 days. That motion has to be heard within the 45 days of the judgment. And that does not stay the appeal deadline or a writ of eviction. So they can file a motion to set aside a default judgment for various reasons. That is, not something that you want to have to rely on as your defense. And then after a writ of eviction is issued, so a writ of eviction could be issued as early as the day of judgment, cannot be scheduled to be executed until day 11 because you've got that 10-day appeal period. Often, a writ of eviction is only issued, the landlord has to go to the clerk's office and file a form and pay a fee to ask for the writ of eviction. Often landlords will do that after the 10-day appeal period is expired, but sometimes they'll do it before then. After that writ of eviction has been issued, the tenant can file a motion to quash the writ. And one of the reasons for that might be that since the judgment, the landlord accepted rent, but never gave that notice of reservation, which, as we said, it has some new language in it in recent years. So it's worth checking on that. If the tenant has paid rent since the judgment, there was a new lease since the judgment, which created a new tenancy. So the tenancy that they won that judgment on no longer exists. There's a new one. Or the date of eviction is within the 10-day appeal period, or more than 30 days after the writ was issued. Writs expire by law after 30 days, and thankfully we've had a couple of clients who that was useful for them because the writ was scheduled to be executed on day 32. That's not something that is self-executed, obviously. So a tenant has to raise that and ask the court to quash the writ. So there's the extended right of redemption, which, as Christy said, so historically that was available up until and through the return date, but thankfully it has been extended by law. So the statute says that a tenant can pay everything that they owe up to 48 hours before a scheduled eviction and get that, and that's exercising their right of redemption. The eviction has to be canceled. The budget amendment from August 10th, 2021 says that if the case was only about unpaid rent, then if the tenant has remedied their non-payment, a landlord cannot take action to evict them. Doesn't give a 48-hour deadline. So it's worth trying. If the tenant has been able to pay everything that they owe, you could ask for a judge to quash the writ based on that as well, even if it's within 6 hours of the eviction or something. And then if you own
but I will say for that kind of argument, they definitely need an attorney. So it definitely needs to be flagged for the staff to refer it to the local legal aid. Yeah,
and that is one of the for things like this, for anything that is post-judgment, especially after writ has been issued, these are defenses that somebody might have. For the volunteer attorneys who are on the helpline, they should flag those defenses, and our staff attorneys will take it from there. And so if there is something that a tenant can do on their own, we can arm them with the right court forms and instructions. If it is something that really needs a legal aid lawyer, we can try to get a legal aid lawyer to help them. Then if the if the tenant owns a mobile home and the landlord of the mobile home park has gotten a judgment to evict the tenant, then within 90 days of that judgment, if the tenant is current on lot rent, the landlord has to allow them to leave the mobile home in the park for 90 days before they have to move it out. In those 90 days, the tenant can try and sell the home or rent it to somebody else, who would then need to, either the purchaser or the renter would then need to enter a lease with the landlord of the park. But you have 90 extra days in there before you have to actually remove your mobile home from the lot. And then finally, as we just mentioned, in practice, very few defenses are realistic for pro se litigants. So we are trying to sort of push the limits of that and get better and better pro se materials and instructions to people. And thankfully, we've had some very happy results with some of the folks that we advise. But in reality, redemption is one thing that a tenant can raise on their own if they come to court with that money, or if they pay that money after court and the landlord goes ahead and cancels the eviction. They don't need a lawyer to do that. Maybe a simple defective notice. So a landlord that gave the tenant a 5-day notice, and that notice doesn't have any of the additional information required under the budget amendment. Hopefully a tenant could, with a little instruction, could show the judge that notice, and the judge would dismiss the case. Maybe non-compliance, as I mentioned, with the RRP requirements. The notice requirements that the non-compliance with the requirements from the August 10th budget that the landlord cooperate in applying for the rent relief program or independently applying for rent relief for the tenant. Maybe non-compliance with those things a tenant could raise as a defense on their own. But that's why it's very important that we in the Eviction Legal Helpline refer clients with potential defenses to legal aid or other representation. This is something that BPLC does as a follow-up on our Eviction Legal Helpline advice calls. And the legal aid lawyers on the ground who are practicing in the general district courts, they're the ones that know better than we do what defenses are going to fly and what are not going to fly. They know the judges. They are training the judges on what these new laws mean. And so they're really the best bet for folks who seem to have a defense, and we can refer them to legal aid. Okay, so now we get to the fun stuff, which is the introduction to the Eviction Legal Helpline. So the Eviction Legal Helpline was started up in response to the eviction crisis that we discussed at the beginning of the presentation that kind of made a splash in 2018. And the purpose of the Eviction Legal Helpline is to provide tenants from anywhere in Virginia with free and accurate legal information and legal advice from an attorney about their potential eviction. We do not provide representation either in court or in negotiating with landlords, but we do, for a fair number of the cases, refer the case to the local legal aid program. If we have time before, say, the scheduled eviction or the court date or whatever, and the caller seems to have a legitimate defense and they're eligible for legal aid, we will refer their case to the local legal aid. The Eviction Legal Helpline is a different kind of model from most legal helplines. There are many legal helplines around the country, in legal aid programs and related legal services. Almost without exception, they are staffed by staff attorneys and paralegals. We thought that because eviction is such a discrete issue, and both the issues that come up and the defenses that are available are really limited compared to other areas of law and other types of legal problems, that we can effectively train and supervise volunteers, both non-attorney volunteers to do the intake and attorneys to provide legal advice, and that with good training, support, and supervision, we could provide effective and competent legal advice and get valuable information to a much larger number of our neighbors who are facing potential eviction. So that is really the model that this was built on. And the idea is to put a dent into these huge numbers of the huge gap in access to justice for our neighbors who are facing potential eviction in Virginia. So there's a basic case life cycle for a helpline case. It starts with an incoming call, of course, and depending on the time of day and the issue that somebody selects in the voice menu, they will either be connected with a call center agent, which we use for folks who have sheriff's evictions already scheduled. The most urgent cases will talk immediately to a call center agent who can do the intake. Otherwise, they will leave a voicemail. That all gets saved into the case record in our case management system, which is based on the Salesforce platform. The second step is that non-attorney volunteers will do the intake. So they will either open a case and listen to the voicemail, get the information out of that, and populate the case record with as much information as they can from the voicemail, and then call the person back and get additional necessary information. Or they will open the case that a call center agent has already gotten most of that information for. In either case, then our intake volunteers will look at the court records that are available online to try and identify, what the deadlines are, what the procedural posture really is, if somebody already has a recent judgment for possession against them, things like that. And then we'll also ask the client to send documents, or they will receive the client documents that come to our email account and attach them to the case record. So at the end of step 2, we've got a case record that's ready for an attorney to review and advise the client. So step 3 is that our volunteer attorneys open up one of the case records, review it, and then call the client back and give them advice, get additional information, confirm that we understand what's going on and what their needs are. And then, of course, take case notes and leave follow-up instructions if there's any follow-up that's necessary from the VTLC staff. And then in the fourth step is that VTLC, for all of the cases that our volunteer attorneys handle, will review that case, the case notes, make sure that the advice seems appropriate, and follow up with the client as appropriate. If the client has a defense, then we can evaluate it more specifically, and we can give the client more specific advice, or ask them if they would like us to refer their case to a local legal aid, and then we close the case and refer it to a local legal aid if that's appropriate. Sometimes we will follow up with pro se instructions for them to take to court, and if they're not eligible for legal aid or something like that. So that's the basic life cycle of a case, and ideally we like that to happen within a few business days of somebody calling us. Now, as call volumes sort of wax and wane, sometimes it takes longer, but for the urgent cases, somebody's got court coming up very quickly, or they've got a sheriff's eviction already scheduled, those cases we do jump in and address very quickly. So that is the life cycle of a case. This is just a basic summary of the process that a volunteer attorney goes through when they are helping out on the helpline. So you'll log into the case management system. You select cases from the menu that shows up and the advice view of those cases that are waiting for advice from an attorney. Select a case from the advice queue, and then you look at the names to ensure that there's no conflict that you know of already. If there's not a conflict that you know of, then you click the accept button to remove that case from the queue so that another attorney doesn't grab it at the same time. You review the case record, the notes that were made, and all the information and any attached files, so notices that the tenant sent, things like that. And then you will probably refer to the helpline reference materials to identify potential defenses based on what the facts are that you know from the case record. And then you call and talk to the client and advise them, get additional information, make sure you do understand what the facts are and what the situation is, and then give them advice. Sometimes they will not be available until you leave a voicemail, and we've got scripts for exactly what you can say when you leave that voicemail. Then you enter the case notes and follow-up instructions. Click save to save the case, and then click a button to assign it back to a queue. After you've already given advice, it's not going to go back in the advice queue. It'll go back into a different queue, like the follow-up queue, and then we will take it from there. That's the basic process. Nothing unfamiliar to lawyers from working with your case system and case management system. So one of the things that is super helpful is we've got excellent reference materials for you, and some of those we've shared with this training. But we have a volunteer manual. Volume 3 of the volunteer manual has step-by-step instructions for how to advise somebody and keep those records in the case management system. And when I say step-by-step, I mean literally it's got screenshots of what you'll see on the screen, and it's got numbered steps of the steps that you will follow, including as appropriate scripts. So as I mentioned, sometimes you'll have to leave a voicemail. Well, we've got a script that says, here's what you say when you're leaving a voicemail if this is the first attempt that we have made at advising this person. If it's the second attempt, it's a slightly different script. Third attempt, slightly different script. And then we have the Helpline Eviction Defenses outline, which is one of the materials that is distributed with this training. It lists all of the defenses that we have gone over and more, and you will refer to that. It includes, as you'll see, the text of many statutes. And then we have some other materials that we've also included with this. So an outline of defense specific to the pandemic right now. And we also have a checklist that you can go through to identify issues, make sure you're not missing obvious potential defenses and other materials. We also have excellent support. We are available almost all the time, certainly almost all business hours and even into the evenings if you need legal support. So if you have any questions about a case that you have looked at or either before or during or after speaking with a client, you can give us a call. Our housing attorneys are available by cell phone, text, or email to answer any questions. And we also offer technical support. Our helpline coordinator, Annika, is fantastic, and she's available by cell phone and email to help with questions about the software, other logistical issues. What is the commitment that we're asking for from our volunteers? Well, it's a very light commitment. So we are asking that a few times over the next year, you take a shift on the Eviction Legal Helpline. The shifts, you can sign up on a calendar. The shifts are 3-hour time slots, and the exact duration is very flexible, and the exact timing is very flexible. So if if you're available on a Tuesday afternoon and you see the Tuesday afternoon shift listed on the calendar is from 1 to 4, but you're available from 2 to 5, or maybe you're only available from 1 to 2:30, that's fine. Take that shift. Maybe make some notes to let us know what to expect, but it's very flexible, and it doesn't have to be a commitment for once a week or once a month. It can be as you have time available. You can sign up for a shift. As I mentioned, we have support available on call almost all the time. You'll also be covered under BPLC's malpractice insurance. Under Rule 6.5, you will not have to run conflict checks on these cases. If you notice that a name that shows up for a party is a conflict for you, just skip that case, go on to the next one. And then if you have limited Virginia bar admissions for corporate counsel, or if you're emeritus, that's fine. We can use you. So what we have had in the past, last year, we had almost 1,500 total volunteer hours, both attorneys and non-attorneys, on the Eviction Legal Helpline. This year, we're on track to have more than 2,500. So we're hoping that next year we can increase that even more so we can serve more people. And folks like you hopefully will help get us there, and your colleagues. So what difference does this really make? Well, some tenants can fight and avoid eviction. Regularly, we are able to help tenants that are in that situation and that do avoid eviction. Even tenants who don't have a defense, though, they might be able to avoid a judgment for possession on their records when we give them an orientation of what the process is and what their rights are. And they can make better decisions, and maybe rather than fighting to the death on a hopeless case, they can move out before the landlord files files an unlawful detainer against them. It helps keep landlords honest. Of course, most landlords are honest. They're doing the right thing. Some landlords, like anyone else, will do what they think they can get away with. And so we are able to help tenants to keep the system and keep the landlords honest. And then even a short delay in displacement can make a world of difference for many people. So you can imagine folks who just don't have other resources and need a little more time to have a soft landing from their displacement rather than a hard landing. Just getting a delay in their case can even help a ton. So then you can see the quotes on the screen from some of our clients. It makes a big difference for our neighbors who are facing eviction and displacement. And we really hope that you will help these folks out by taking a shift on Eviction Legal Helpline. The way to do that, the way to get started, is to go to evictionhelpline.org and go to the potential volunteers page. And we'll follow up with an email to everybody, but there are instructions there for filling out the volunteer information sheet and volunteer agreement, and then signing up for shifts. So that is a briefest of introductions to the Eviction Legal Helpline. There is plenty of fun to be had there, and we are happy to answer any questions you have. Happy to let you do sort of a ride along with us on an advice call that we do with a client. Anything that will help to make you feel comfortable